One of the certainties in life is death, and whilst many of us are quite rightly try to ignore this reality, what we also often ignore is the importance of a will. I am with Bridget Rhienberger, a lawyer with experience in estate planning, to discuss this issue. Thanks for joining us, Bridget. As a starting point, Bridget, what happens if you die without a will?
If you die without a will, you die intestate, and your estate will be distributed in accordance with the statutory formula set out in the state-based government legislation.
Can you outline briefly what the main legal requirements of a will are?
When it comes to making a will, the testator must be of sound mind. The will must be in writing and it must be signed at the end of the will by the testator or at his direction. The testator's signature must be witnessed by two independent adults who are present at the same time and who are not related or married to the testator and who are not beneficiaries of the will.
In your experience, what are some of the more common estate planning mistakes that you have found?
Failing to keep your will up to date, taking into account your changing circumstances such as marriage, divorce, children, changing assets, failing to express your intentions clearly, failing to take tax or Centrelink benefits into account when making provision for beneficiaries, and trying to gift assets that aren't owned by you, for example, trust assets, company assets, or assets held within superannuation.
Finally, can a will be challenged?
It's a really difficult and costly process, but a will can be challenged. And the most common areas of challenge are, firstly, that the testator didn't have sound mind. The second way is the Testator's Family Maintenance Act, known as family provision legislation. This makes a will vulnerable because the testator failed to or didn't leave adequate provision for a particular family member, usually a spouse or children. And while it's not strictly an area of challenge, if a will doesn't meet the formal execution requirements, it's vulnerable to challenge as well as not forming a proper will in the first place. Essentially, it's a complex area and it's worth seeking advice.
Thanks so much for your time, Bridget, and outlining some of the important issues when creating a will. If you've got any further questions, please don't hesitate to contact us.